All right, good morning, everyone. I'm Commissioner Easterday. Welcome to my Thursday morning default hearing calendar. If this is the first time here appearing before me in a default matter, I do have a number of matters. They're all set. I'm going to call each case one at a time. I'm going to thank you in advance for your patience as we move through this morning's calendar. Again, good morning. So first matter I'd like to call is in the matter of North Mill Equipment Finance LLC versus Rapid Response Disaster Services LLC et al. This case number is CV 2025-067957. Can I get appearances, please? Speaking with counsel for the plaintiff.
Good morning, Your Honor. Olivia Rafferty, counsel for the plaintiff, North Mill Equipment Finance LLC.
Good morning, counsel. Do we have an attorney on behalf of Rapid Response Disaster Services LLC or any of the other individual defendants joining us? Judging by that silence, I'll take that as a no. It is 9:01. This matter was set for 9 o'clock. There's no one waiting in my virtual lobby, waiting to be admitted into my virtual courtroom, so it doesn't appear that any defendants or defendant's attorney are timely appearing. So, Ms. Rafferty, how are you looking to proceed this morning?
Your Honor, plaintiff is requesting the entry of a default judgment against the defendant, Rapid Response Disaster Services LLC. The defendant was served on April 10th, 2026. Pursuant to ARS 29-3119B by mailing the documents to the entity's principal address as listed with the Arizona Corporation Commission, following numerous unsuccessful attempts to serve its statutory agent. The defendant then failed to answer or file a responsive pleading, and plaintiff filed an application for entry of default against the defendant on May 12th, 2026. And again, the defendant failed to appear or otherwise answer. This action arises out of the breach of an equipment lease agreement. The Partners Capital Group Incorporated entered into that agreement with the defendant for the acquisition of a 2021 Ultrasonics International Fireline Series system and corresponding accessories. That agreement was subsequently transferred and assigned to the plaintiff. The defendant ceased making payments under that agreement as of May 15th, 2025, and this failure to make payments constituted a default under Section 13 of the agreement. Pursuant to that same section, the plaintiff was entitled to accelerate all sums due and owing. The principal sum of $48,984.97 remains due and owing under the agreement, plus interest at the rate of 18% per annum, pursuant to Section 13 of the agreement. Additionally, plaintiff was granted a security interest in the agreement, and upon default, plaintiff is entitled to repossess the equipment. Section 13 of the agreement also entitles plaintiff to its reasonable attorney's fees and actual court costs incurred in enforcing the agreement. Those attorney's fees total $6,201, and the costs incurred total $1,141.73. Plaintiff seeks post-judgment interest on the attorney's fees and costs at the statutory rate of 7.75% per annum, and respectfully request that the court enter judgment pursuant to the proposed form that has been submitted to the court.
And it looks like the other two individual defendants were dismissed because of their bankruptcy, correct? So the only remaining defendant is the LLC, correct, counsel?
Yes, Your Honor.
All right. Well, based upon that, just wanted to make sure my T's are crossed, I's are dotted.